Mr. Otti.
My lords, my lady, we took advantage of the fact that we broke slightly early yesterday and that we broke at a point when we'd heard Sir Daniel's submissions and Mr. Swaroop's introduction to spend some time last night and early this morning putting together a note of reply, a note of our reply submissions, which I hope should be before each member of the court now.
I'm not sure it is. It is behind us, not before us.
Sorry.
Thank you.
Thank you. Right.
And what we've sought to do, I hope to facilitate an early finish today, is to set out what we see, or our position on what we see as the key issues in the light of the debate of the last 2 days. And the first important area is the alleged factual background. I emphasise, of course, the word alleged. But it's important to understand how high we put our case. As we say in paragraph 1 of this note, it is not our case that the respondents here were mere end users. It is our case that they were perpetrators of trafficking. It is our case that they were involved in deception, that they were involved in receipt and harbouring in abusive and exploitative conditions, and that all of that culminated in my client's flight from their residence and recovery of her passport from the police. Now, the point that is taken against me is that, notwithstanding the fact that that is our case, the absence in our pleading of the words deception and the word trafficking means that we cannot invite this court to conclude that this case does relate to trafficking. Now, that submission we respectfully submit is entirely unrealistic for the reasons which, to some extent, were canvassed in argument this morning. And we've set out in paragraph 2 the core materials that we say it's proper to have regard to in this connection. We've set out the statement of claim first, with each of the pleaded allegations and the paragraph references to those, embracing a promise of payment and a failure to pay, the provision of false information to United Kingdom authorities, a requirement for grossly excessive working hours, very severe restrictions on contact with the outside world, whether family or otherwise, very severe restrictions on proper conduct and treatment within the home, a departure from the home in a state of desperation, and an allegation of direct race discrimination. In addition, this is little b, by the time the matter comes before the employment tribunal, in addition to the statement of claim, there is a witness statement from Ms. Reyes, an expert report from Kalyan, the stated purpose of which is to provide evidence about how diplomatic immunity facilitates trafficking, and the stance of the respondents themselves before the employment tribunal, which we've set out at little c, where they were inviting the tribunal to proceed on the basis that the facts...
Let's work on the reference to the statement of claim, the statement, is that right, CV2 175?
I hope so, my lord. Let me just check. Yes, it is. I'm
Maybe
sorry,
it
it
is.
should be MS 781.
So it's not yes, I see.
No, you're quite right, my lord. It's the internal pagination. MS 781.
Thank you.
So those are the materials that are before the tribunal, in which it's manifestly obvious that trafficking is in play in the materials before the tribunal. The respondents themselves then say to the tribunal, we'll proceed on the basis that the pleadings are true. Article 4 of the Convention, the prohibition on slavery and slavery-like practices, is expressly in play before the tribunal. And it's clear from the tribunal's reasoning that the respondents knew at that point that it was being alleged that Miss Reyes was the victim of trafficking and that they were the perpetrators. And it was then debated before the tribunal how to proceed. And the approach adopted is that set out in Little Roman 4. Now, in addition to that, by the time the claim was before the Employment Tribunal and that debate was taking place, the UK's competent authority, the UKVI, had concluded that there were reasonable grounds for concluding that Miss Reyes was indeed a victim of trafficking. We've given the reference to that. Now, the reasoning had not been published at that point, but the reasoning is now before the court, and we've given the reference to that, and you've seen it during the course of Mr. Swaroop's submissions this morning, and you'll recall that it includes reference to the Anti-Trafficking Convention definition of trafficking. It concludes that there are reasonable grounds for believing Miss Reyes to be a victim of trafficking by reference, amongst other matters, to a question of deception. And it includes the list of the 10 indicators of trafficking which the Court of Appeal has found were pleaded in these proceedings. The final point on this issue at little e is a not insignificant one, we respectfully submit, and it relates to two aspects of the government's stance. Firstly, the one that we've already emphasised in argument, that the government sees employment proceedings as a key means by which victims of trafficking are able to seek redress. And secondly, that in his intervention on this appeal, the Secretary of State does not seek to challenge the Court of Appeal's finding that these proceedings are properly characterised as relating to trafficking. That is a point that is only taken by the respondents. Paragraph 3 and 4 seek to draw those points together, but they make an additional, we say, potentially important point, depending on the extent to which the court considers it appropriate to look at the Travo and to consider concepts of continuous activity or not. Even looking at Miss Reyes' case alone, her complaint is not about a one-off incident. It is about a course of conduct spanning a period of just under 2 months in which she was the victim, on her case, of systematic abuse. But the factual matrix against which this case falls to be considered is not limited to Miss Reyes' case, because as we have pointed out at paragraph 16 to 20 of our printed case, and this is the point made at the end of paragraph 4 of this note, the factual matrix also embraces the plight of Miss Suryadi, the individual who immediately succeeded Miss Reyes. And on the factual allegations, she was subjected to strikingly similar conduct, which we say would be admissible in Miss Reyes' proceedings. And it's illustrative of, we say, on our case, this not being, on any view, a single plunge into the waters. This is evidence of continuous activity of an internationally wrongful kind. And materially, for present purposes, we say continuous activity of a commercial kind. Now, just on paragraph 4, I wanted to add 3 points by way of emphasis, if I may. Firstly, as will be apparent from the way I started my submissions this afternoon and the summary that is set out there and elsewhere, this is a case where we allege knowledge and perpetrator status without any hesitation. Secondly, on a point of detail that's raised about whether or not we can show that the conduct complained of was for the purpose of exploitation, a similar question was addressed in Haunger, and a similar question was debated as to whether it was safe to conclude that trafficking had occurred and the claimant was a victim of trafficking, absent specific findings about purpose. Now, this is, we say, readily solved in the way it was solved in Haunger at paragraphs 47 to 49 by step one, the assertion that the conduct complained of was deliberate. Step two, it was exploitative in nature. And step three, it is to be inferred, therefore, that it was for an exploitative purpose. And that essentially, as we see it, was the route by which in Haunger the court was in the end comfortable to conclude that this was a victim of trafficking case, or that was, I should say, a victim of trafficking case. And the third point in relation to paragraph 4 that I just wanted to emphasize, in response to a submission made by Mr. Swaroop this morning, where he was complaining about the reference to indicators and the reliance on indicators. The International Labour Organization, the oldest United Nations agency, had set out its 6 indicators in, or rather, its then 6 indicators were set out in Haunger. As I said when I was opening this appeal, those indicators have now been updated, and the current indicators are at bundle A13, MS 5079, where 11 indicators are set out.
Yeah, we looked at them.
And if one looks at those indicators, firstly, the International Labour Organization is saying that the presence of a single indicator in a given situation may in some cases imply the existence of forced labour. In other cases, you may need to look for several indicators which taken together point to a forced labour case. Now in this case, we say we have at least 8 of the 11 indicators present. Abuse of vulnerability, deception, restriction of movement, isolation, retention of identity documents, withholding of wages, abusive working and living conditions, and excessive overtime. So there's nothing outlandish or radical about invocation of indicators, and the facts of this case readily show that sufficient are present on the alleged case to lead to a conclusion of forced labour and servitude, which then feeds in to the anti-trafficking definition. So that is the case as it is put, as a matter of fact. The question then is, and this is the next question we address in this note, how do the courts approach a contested factual background? 2 preliminary points, if I may, on this. Mr. Swaroop asserted, both in writing and this morning, that there will never be a finding of trafficking, whatever the course of these proceedings. Now, that is not correct if the court is with me on our submission as to the construction of commercial activity referable to trafficking, because if that is the test that this court lays down, then the Employment Tribunal will in due course need to make a finding on whether this is indeed a case of trafficking. The Employment Tribunal, of course, has full jurisdiction to resolve immunity issues, and if, as part of doing so, it has to answer a question posed by this court, then it will do so. So it's simply a false point to say there will never be a finding of trafficking, even if we are right. There would have to be. The second preliminary point is this, which is that many of the points relied upon by Mr. Swaroop to suggest what he characterises as an invidious fact-finding exercise would fall away if the court were to take the broader approach of saying that ordinary employment relationships involving personal servants not touching upon state sovereign functions are within the meaning of commercial activity, because there would be no need to go any further than that for the purposes of resolving that. In any event, on either approach, it's clear on all of the authorities that there's nothing novel about this situation and there's nothing problematic about it. And it's manifestly apparent, we say, from the fact that exceptions are permitted by Article 31(1)(c) and the other provisions in Article 31(1), that some kind of exercise of this nature may be needed. So at paragraph 5, we've identified the two approaches which are taken on the authorities. Either you take the claimant's case at its highest and consider whether immunity is made out on the basis of it, and it may be that a diplomat can succeed on that basis and say, even if this case is accepted to the hilt, it won't be good enough. C. Jones as one example. Or the court can decide that a fact-finding exercise is needed. And we've given a series of examples of each approach in paragraph 7. And indeed, we referred to...
I suppose in Jones it was easy. On putting the claimant's case, taking it at its best, they still failed.
Exactly.
So that's easy.
That's easy.
But if taking it at the best they'd succeed, then you may have to cast around a little bit further to see whether you should inquire more deeply.
Exactly so, and there's nothing objectionable about that process, and it's a process the courts have been shown themselves to be willing to undertake. We've given at 7C the example of the United States case that I couldn't find the reference to on Monday when this issue came up in my exchanges with my Lord Clerk, Swama, where the United States approach is to say, well, we accept the truth of the plaintiff's allegations and we'll construe all reasonable inferences from those allegations in their favour to test the immunity point. And then at paragraph 8, at little a and b, first of all, picking up on references we'd already made in our printed case at 65, we've drawn attention to the fact that even in the world of state immunity, governed by the common law, there may be need for a factual inquiry because it may be necessary to try to characterise accurately the conduct that is in issue, whether it is sovereign, whether it is private. And one of the cases at 8C that I did go to on Monday, El Haddad, was an example again from the United States of the Court of Appeals taking the view that there was at least potential for immunity not to apply, and it was necessary to pose a series of questions for the lower court to establish the true nature of the employment relationship in issue. So nothing novel or problematic in the approach we contend for. And as we say at paragraph 9, the one approach for which there is no support whatever in any of the authorities is that apparently contended for by the respondents, which is essentially to shut out a claimant's invocation of an established immunity exception because of the absence of prior findings of fact. And the simple answer to that, apart from the fact that it has no authority anywhere to support it, is the one we've given and the one that was canvassed in argument. You might well have cases concerned with what could be characterized as classic examples, indisputable examples of commercial activity involving very serious allegations of fraud, for example. It could not be open to a diplomat to simply say, I deny these allegations. It would be invidious for any findings to be made in relation to these allegations. Therefore, I have immunity. But that is essentially the logic of the respondent's case. We've, at paragraph 10 and 11, sought, I hope again, accurately, to summarise what our case is on this appeal. we don't rely upon the high status of the prohibition of trafficking for the purposes of displacement. We do rely upon it for the purposes of harmonious interpretation. And if we get to it, we rely upon it to show that whatever guidance provided by the Travo is entirely adequately satisfied. We say this case falls to be decided clearly in Ms. Reyes' favour by reference to the Vienna Convention on the Law of Treaties and the terms of the Diplomatic Convention itself. If we're wrong about that, and we can only establish a lack of clarity, and that there's a state of ambiguity about Article 31(1)(c), then it is there, we say, that the additional principles come into play to support us and to bring us home. Now, there was one policy argument identified. I'll come on to the other arguments, but there was one policy argument identified by Sir Daniel for the purposes of his submission that you should take no guidance from the law on state immunity in this area. And the one policy point made was that diplomats are corporeal persons, and so they face a particularly high level of vulnerability which does not apply to a state. And we have set out at paragraph 12 5 points which we say illustrate that that point is not capable of bearing the weight that the respondents place upon it. If that point about vulnerability of real people had substance, then it would have led to the drafters of the Vienna Convention conferring absolute immunity from civil proceedings in the way they chose to confer absolute immunity from criminal proceedings. And this is, to put another way, precisely the point that was put in one of my Lord Sumption's questions, that if the concern for the individual diplomat was that they might face trumped-up allegations, then that concern exists on the agreed exceptions recognised by all states in Article 31(1). The second point is that it's an overstatement in any event to suggest some terrible vulnerability will be faced by the diplomat if we are right. The diplomat will retain the ability not to comply with any witness order that the employment tribunal might issue. He or she will retain the right not to give any evidence at the proceedings. He or she will retain immunity in respect of enforcement at his residence, immunity in respect of disclosure of documents from his residence, and to some extent from execution of any judgments as a result of the other provisions of the Convention. Now, against that, this is little d, the only instance of a case causing problems which my learned friends were able to point to was the Cobregade case, the one concerning the Indian diplomat. But that is not, we will respectfully submit, a remotely apt comparison in circumstances where that case involved an assertion of criminal jurisdiction and the arrest of a serving diplomat. Quite obvious that the assertion of criminal jurisdiction and physical powers of arrest would impact upon personal vulnerability, and quite distinct from the employment proceedings assertion of jurisdiction here. And finally on this, we say the respondents were simply unable to articulate why, as a matter of policy, the drafters of the Vienna Convention would have considered it essential to the discharge of diplomatic functions to provide for immunity from claims relating to modern slavery. And unless we missed it, we were never told the respondents' position on whether involvement in trafficking is involvement in commercial activity. The first point in our case summary on the first day that trafficking was inherently commercial in nature, and the respondents remained silent on that point. So that takes me then to the interpretation exercise that Sir Daniel engaged in principally yesterday, and the VCLT exercise of interpretation, a naked interpretation, as he put it, of the provisions of the Diplomatic Relations Convention. And before addressing, as we do at paragraph 14, the provisions that he relied upon particularly, I just wanted, and we've drawn attention to this in paragraph 13, wanted to draw to the Court's attention the extract from Gardner on treaty interpretation that was handed up with my note just now. Because that extract, we say, shows that it is an unnecessarily stifling and incorrect approach to say that the meaning of a treaty is fixed for all time as at the date of its conclusion. And that is particularly clear, we say, when the treaty in question is intended to last for a very long time, and where the treaty in question uses generic, undefined terms such as commercial activity. What was perhaps even more remarkable about the respondents' stance on this issue was that they sought to exclude everything that had come before in the form of treaties prohibiting the slave trade, and they sought to exclude everything that had come afterwards in the form of treaties recognizing what modern slavery looked like. And we respectfully submit that that is a quite unrealistic approach. We do invite the Court to proceed on what we say, notwithstanding the gravity of the subject matter, is a not remotely outlandish premise, namely that if the drafters of the 1961 Convention, when including a provision about commercial activity, had been asked the question, by the way, would engagement by a diplomat in the slave trade, emphasis on the word trade, constitute commercial activity? The answer would have been, of course.
Well, by the slave trade, you mean buying and selling slaves?
I mean, yes, and the definition of slavery is important here, my lord, as well. The assertion of rights of ownership over an individual.
Well, by the slave trade, I think you mean buying and selling.
My lord, yes. And the trafficking trade.
And transporting.
And transporting. And agents recruiting and so forth. The buying and selling is the most obvious example.
Transport people for the purpose of buying and selling.
Yes. And you could recruit people for the purposes of selling, and you could receive people knowing the circumstances in which they had been bought and sold.
Well, but a person who bought the slave at the other end would, however reprehensible his behaviour, he would not be engaging in the slave trade. After all, on that footing, slavery would have been illegal in the United States for 50 years before the Civil War, because they made the slave trade illegal for 50 years before they made slavery illegal.
My lord, yes. Yes, no, I take that point, but the broad thrust of this point is that treating of human beings as commodities would have been readily recognized as unlawful and would have been readily recognized as engagement in commercial activity, even at 1961.
But I think it's suggested on the other side that what we have here is something short of commercial activity.
Exactly.
My lord, yes, and that's why it's important. Paragraph 1 of our note is important, because we are not concerned here with a situation of mere end user in ignorance of what has gone before. We are not concerned here with mere payment of sub-market wages in ignorance of what has gone before. We are concerned on our factual case with a chain of activity for the purposes of exploitation, which these respondents are involved in from day one.
Yeah, but you could say the same then if I employ somebody through an employment agency. perfectly lawfully. The employment agency clearly is in the business of employment. But the fact that I take somebody from an employment agency and contribute to their business and pay in accordance with their payment, possibly pay the employment agency rather than them, doesn't mean I'm anyway engaging in business in doing that. And one's got to be very careful. The fact that they are facilitating it by what they do doesn't mean that they are therefore engaging in that business or any business.
Well, my lord, they are engaged on day one in this process.
Well, no, it's all very well saying that, but actually what are they doing? I mean, if I employ somebody as a maid or gardener or chauffeur or whatever, I'm not, on the face of it, engaging in commercial activity unless you give it a very wide meaning. Now, the fact that I hire them or whatever, or employ them perfectly lawfully and properly from an employment agency that clearly is carrying on business doesn't mean that I'm in any way involved in that business. Now, the mere fact that I facilitate that business, if it wasn't for people like me doing the things they expect me to do, that business wouldn't survive, doesn't make me, therefore, part of that business. Now, why is it different? I know this is a horrible thing if human trafficking, and if it's gone on here, it's reprehensible. But why is it any different? Why are they involved? Simply because they take advantage of somebody else doing this wrongful act?
Well, you have the factual point that they're not simply involved at that taking.
Well, you say they're not simply. How are they involved in a different way from what I would be involved in if I was employing somebody perfectly lawfully?
Because on the facts alleged here,
yeah,
their purpose is exploitative.
Well,
the commercial element, I think you said when you opened this, is supplied by the financial benefit of obtaining the services at less than the legal minimum and indeed less than the market rate. Let's assume all of that.
Yes.
The question is whether the existence of a financial benefit of that kind is enough to make it commercial.
but if I make enormous profit out of somebody working for me, I perfectly lawfully, because they work for me, they're a very good chef who I entertain my business colleagues at home or other people at home. The fact I make a profit out of that, but he's my cook or she's my cook at home, does that make it a commercial activity?
Well, my lord,
I benefit from it financially.
We say, forgetting about any of the case law, that the deliberate engagement in a course of activity intended to yield a financial benefit is commercial activity.
So if I pay somebody below the going rate, I'm not indulging in, I get some innocent person who is not very well aware of going rates, I underpay them. I pay them less than the minimum
My lord, yes.
rate. Then I'm indulging in commercial activity.
On the authority of the Supreme Court in the Canadian Labour Code case, yes, you are.
I see.
On the authority of the Supreme Court in Portugal, yes, you are.
So the mere fact that I'm underpaying somebody brings me in.
Yes.
I see.
On the authority, on the United States cases on state immunity, yes, you are. So, and even...
That's a different question, because that's the question whether the relevant activity is an exercise of sovereign authority.
There were two questions, my lord, in the Canadian Labour Code case. One was, is a bare contract of employment properly characterised as commercial? And the answer to that was, yes, it is. And that is, we say, an answer to my Lord Newberger's point. The second question, which arose in the Canadian Labour Code case, was, are these proceedings, which are related to union certification challenges, related sufficiently closely to that commercial activity? So on the material question here, we say we're strongly supported by the approach that's taken in the state immunity context. We say even without that case law, the yielding of a financial gain is sufficient on the natural meaning of the words. And so far as that's concerned, we also have the support, we say, of the diplomatic immunity case law, even Tabion, which acknowledges that the literal meaning of the words commercial activity is sufficiently broad to embrace that. And then we have the further support from the Canadian and the Portuguese first instance decisions.
I'm just wondering how far this goes. I mean, almost anybody could say, well, I could have, if the employee says I didn't do a good deal and didn't charge enough, that's it.
That may be why, in the end, and if one has regard to the Travaux as well, if the court is willing to look at the Travaux, in the end, the less far-reaching course, of course, is to find in Miss Reyes' favour on the basis of the trafficking element.
I understand that. That's what I'm examining. Why? Of course, if you establish what you've just been discussing, then we don't have to worry about trafficking.
No. And the only stage really which means that you do have to worry about trafficking, on the way I've just been exploring the case with my lord, is if you look at the Travaux. Because it's the Travaux which contain the references, assuming against me for the moment that they're sufficiently consistent and widespread. It's the Travaux which contain the references to Article 29 or 31 being intended to capture conduct which is inimical to the dignity of the mission.
We can cut it up with, is employment enough? If so, you're home and dry.
Exactly.
Is employment at a discount, as it were, enough? If so, you're home and dry.
Yes.
If we then get to the third stage, if you fail on those two, if trafficking is added in,
yes,
the mix, is that enough?
That would only need to come in to make the difference if
you fail at the first two hurdles.
I'm sorry, Molly, if I fail on the first two, and if the court considers that the adjectival characterisation in the Travaux is of relevance in determining the meaning of commercial activity,
that depends.
They may feed into each other.
Yeah, well, it all depends what we think about the first two. But
yes,
if you get home one eyes with them, then we don't have to worry about the trafficking.
That's right.
Plainly right, yeah.
And if we say we get home because of the case law I've just been seeking to summarise, we say we also get home on Sir Daniel's case law-free analysis, the naked interpretation approach. And that's what we then turn to in paragraph 14 of our submissions. And what we've sought to do here is address each of the provisions that Sir Daniel went to. And we say that on analysis, none of them provide the assistance suggested for the respondents, and most of them support Miss Reyes' case. We've got the second and fourth recitals first. The second recital showing, we say, a clear link between the founding rationale of diplomatic and state immunity. We've got at 14c the references to personal servants, which perhaps taken with Article 42 is the most important category to consider. And as we say there, those references don't actually do anything more than show that a diplomat might be expected to retain a personal servant. They don't tell us anything, we say, about whether such engagement would constitute commercial activity. And they don't establish for 1 minute that the engagement of all such servants, in whatever capacity, for whatever purpose, in whatever manner, should be characterised as being within official functions. So they're interesting as providing an insight into what a diplomat might be expected to do, but they don't tell us anything about the meaning of Article 31(1)(c).
I understand.
The next point is the persona non grata provision, and again, that doesn't tell us anything about the meaning of 31(1)(c) against us. Indeed, such material as there is in relation to persona non grata, as derived from the Travaux, it actually supports us here, because it's indicated in aspects of the Travaux that it is conduct capable of leading to a declaration of persona non grata, which is intended to be captured by the exception to immunity in 31(1)(c). And on the facts of this case, it's conceded by both the respondents and the Secretary of State that involvement in trafficking would be capable of leading to a declaration of persona non grata. So if anything, that provision positively supports us. The waiver provisions, likewise, we say support a close relationship between state and diplomatic immunity of the kind we rely upon. 34D, I've already made my submissions on in the first round of submissions. Article 38 was a new provision to be relied upon, and we've set out our position in relation to that. That article confers immunity from, removes immunity from criminal jurisdiction for nationals and residents of the receiving state, but doesn't provide any warrant for rewriting Article 31(1)(c) in the way suggested. And then importantly, we say, given the way the matter was approached in the Court of Appeal and given the emphasis the Court of Appeal and before the Court of Appeal Propend placed upon Article 42, we respectfully submit that the respondent's position on Article 42 in the final analysis is quite a weak one. And we've set out a series of points in that regard. The first is that it was accepted by reference to the example we posited of the pro bono doctor, that the words for personal profit in Article 42 did add something. They were not pure surplusage. The respondents appeared to proceed on the basis that we were contending they were surplusage, but of course our submission was precisely to the opposite effect. They add something to Article 42, and their absence from Article 31(1)(c) is therefore, we say, telling, and telling against the primary approach adopted by the respondents on this appeal and the primary approach adopted by the Court of Appeal. Similarly, there seemed to be some attempt to place importance on the use of the term practice in Article 42 as compared with the word exercise, but that again just served to illustrate another difference in wording between the provisions. There was no explanation as to why, notwithstanding the rather laborious drafting process, if precisely the same activity was intended to be captured by the words in Article 31(1)(c) and Article 42, the same words were not used. And so the position remains, as we sought to summarize it on Monday, that while it is clear that all conduct prohibited by Article 42 would fall within the exception of Article 31(1)(c), there is no good reason, as a matter of ordinary interpretation, to limit the exception to that kind of conduct. So that's the purest interpretive exercise confined to the four walls of the Diplomatic Relations Convention, which yields, we say, an answer in our favour.
Yep.
If one then turns to the Travo, there are obviously two questions which arise. Firstly, is it permissible to have recourse to them? And secondly, what do they say if it is? Now, so far as the first question is concerned, as we say at paragraph 15, there was no attempt by the respondents to engage with the restrictions on recourse to the Travo, which are established within the Vienna Convention on the Law of Treaties itself and established by the House of Lords in this jurisdiction in the Fothergill case. On our analysis, the Article 31 Vienna Convention on the Law of Treaties exercise does not leave an ambiguous or obscure meaning. It leaves one clearly in our favour. It certainly doesn't...
You've left out a few words from Article 32 there, Mr. Otti. Recourse may be had to supplementary means of interpretation, including the preparatory work, in order to confirm the meaning resulting from the application of Article 31. And I rather understood that the argument was, this is our contended meaning resulting from the application of Article 31, and the Travo confirm it.
I'm sorry, my Lord, yes, I may be doing Sir Daniel an injustice. Can I just...
You have 2317.
Well, my Lord, yes, we had...
Anyway.
We had read, I take my Lord's point, we had read the qualifications at A and B as applying to the whole provision, but it may be...
I'm not sure about that, Mr. Otti. Don't think so. Anyway, proceed.
I'll proceed, my Lord. As a matter of domestic authority, we have Fothergill and Lord Wilberforce saying that recourse to the Travo is permissible if they clearly and indisputably point to a definite legislative intention. Now, in the instant case, we say that recourse to the Travo doesn't get the respondents anywhere near that test for the purposes of the destination they wish to arrive at. But in any event, and it's obviously realistic, given the debate there's been, the substance of the Travo, we say, properly analysed, actually supports Ms. Reyes' case rather than hinders it. And it does that for the reasons that we set out in paragraph 75, 1 to 4 of our initial printed case, and that we've then gone through in summary form in paragraph 17.
Yep. That's a helpful summary, thank you.
Diplomatic immunity case law next. 4 points that we emphasise in relation to that case law. We don't meet Tabion solely by reference to the United States doctrine of deference, having no equivalent here, albeit that is an important point. As the court's seen from 51 to 59 of our printed case, we rely upon other reasons for saying Tabion should not be followed too. Secondly, neither that case law nor the United States State Department statement of interest even referred to the earlier Canadian and Portuguese cases, which are consistent with our position. Thirdly, and this feeds in perhaps to the policy point that we've already touched upon, and to the arguments to reciprocity that were made on a number of occasions, there's certainly no evidence whatever that the approach in Canada or in Portugal more than 20 years ago has caused anything like the dramatic consequences that Mr. Swaroop foretold at the end of his submissions this morning. And the fourth point is the point we've made in the footnote at the bottom of that page, footnote 3. When you actually look at the State Department statement of interest, not only does it omit material case law, but it actually acknowledges the commercial activity exception in the Vienna Convention may be said to represent an extension of the general principle of restrictive immunity to the area of diplomatic law, and so lends further support to our analysis and our submission in this case that to drive a wedge between the two would be inappropriate.
Yep.
And that takes me then on to the law of state immunity. And the three reasons that were advanced by Sir Daniel for resisting the invitation to draw assistance from cases like Canadian Labour Code in the Canadian Supreme Court or El Haddad and Park and Shin and other cases in the United States. And the three reasons were: there's a different rationale, the sources of law are different, and substantively different rules apply. Now, as to the first of those, we say the second recital to the Vienna Convention illustrates that there's actually a direct overlap in rationale. The Aldona case relied upon for the contrary position preceded the Vienna Convention by 13 years, and there was no response at all to Lady Fox's views as set out in Sato, the 2017 edition, that we've quoted in little a there. As to the sources of law, it's impossible, we say, to draw a bright line in the way Sir Daniel suggests. Yes, it's true, state immunity is currently regulated by customary international law, and customary international law requires consideration, amongst other matters, of judicial decisions in different jurisdictions as part of its identification exercise.
As evidence of state practice.
As evidence of state practice, my lord, yes. And also as evidence of state practice, regard can be had to domestic legislation and treaty commitments, whatever they may be.
Yes, but they have to be reasonably uniform between different jurisdictions in order to have any weight.
My lord, yes.
The judicial decisions, at any rate, do not seem to be.
Seem to be generally, my lord, or in the context of state immunity.
well, either, but particularly not in the context of diplomatic immunity.
No, my lord, I take that point. In any event, we are looking here for persuasive authority, and we say legitimately admissible persuasive authority, on the meaning of the Vienna Convention on Diplomatic Relations. And it's legitimate in that regard to consider the cases from the United States, the cases from Canada, and the cases from Portugal. So to suggest an entirely different exercise in terms of sources of relevant material is being undertaken is, we say, to overstate the position. And the third point, that, well, the substantive rules are different, is with respect entirely circular. The fact that the scope of state immunity and diplomatic immunity is not precisely coterminous in all circumstances does not alter the fact that in substance, both of them involve something akin to restrictive immunity.
Understood.
Consular immunity, I've dealt with at 21.
Yep.
I hope I was clear when I was opening the appeal. I didn't want to overstate the comparison, but it was of relevance, at least in testing, in particular, the functional point and the corporeal person vulnerability point, to consider the lack of immunity which would apply in a consular context. Article 39.2 and the case law that there is on residual immunity and the extent to which that can inform the court's analysis of the official functions test under 31.1c, we respectfully submit it's wrong to simply brush that aside on the basis that it is concerned expressly with Article 39.2. We say that the spectrum approach of Mr. Justice Langstaff was entirely realistic. And we say that in the end, the respondent's approach ends up depriving the words official and functions of any substantive meaning. And what they seek to recast them as meaning as is something like, and which did not form any part of the ordinary daily life to be expected of a diplomat. And that, we submit, is a distortion.
Yep.
Now, the international law obligations owed to Saudi Arabia and the issue of regional standards. If we are right on our primary submissions under the VCLT approach to the Vienna Convention on Diplomatic Relations, then that will have determined the extent of the United Kingdom's obligations under the Diplomatic Convention.
If you're right so far, there's no problem.
There's no problem at all.
Covered by your claim is within 31.1c, end of story.
Exactly, and Saudi Arabia signed up to that.
Understand that.
Secondly, it's wrong to say that the standards we rely upon in support of that exercise are purely regional standards. And this is, in some respect, a point that was raised in one of Lord Wilson's questions this morning. And we've set out the multilateral, multi-regional materials we rely upon at 24, and we did so in our table on the first day. It's only if we get to a stage of ambiguity that is not resolved by harmonious interpretation by reference to those international instruments, that what might be characterized as the regional instruments, the Anti-Trafficking Convention and the European Convention on Human Rights, come into play. And we've set out our position in relation to that at paragraph 25. We do say that if one is in a position of ambiguity, then Section 3 of the Human Rights Act and the interpretive principles in al-Dalumi provide the tiebreaker in our favour. And just to give the court additional references, if I may, on that question, it's true that Al-Jeddah, Nada and al-Dalimi were concerned on their facts with the approach to interpretation of United Nations Security Council resolutions. But it is also true that particularly in Nada, at paragraph 169, MS 3763, and al-Dalimi, paragraph 138, MS 4115, the statement of principle goes broader than that and refers to international instruments generally and the need for construction in a manner most consistent with the protection of convention rights.
Right.
And Lord, that is all I wanted to say in reply on the appeal. Can I turn to the cross appeal? And so far as that is concerned, I hope the court has to hand our submissions in response to the cross appeal, which were dated the 3rd of May and came in after the bound volumes.
Right.
I'd like principally to refer to that document and to the Court of Appeal's judgment in responding to the way Sir Daniel puts the respondent's case.
Okay.
The issue in the cross appeal is addressed by the... We've got at least one spare copy if anyone's having difficulty in locating that document.
We've got a spare one, maybe I could have it. I did have mine earlier, but perhaps I took it home from lunch. Thank you very much.
Yep.
So this is addressed by the Court of Appeal at paragraph 78 to 95 of its judgment. And the appellant contends that the Court of Appeal was, I should say cross-respondent, I'll say Miss Reyes instead. Miss Reyes contends that the Court of Appeal was right.
You contend. Yep.
I contend, put it even higher than that. I contend that the Court of Appeal was right to dismiss the arguments advanced by the Malkis for 6 reasons.
Right.
And each of them is maintained, notwithstanding the latest intervention by the Secretary of State as set out in the letter of the 11th of May. The first reason is that, as the Court of Appeal found at paragraph 86,
Yes.
the ordinary meaning of the words used in Article 22 does not preclude service by post. Service by post involves no affront to dignity,
Right.
no public embarrassment, and no restriction on movement. And we develop those submissions a little further in paragraphs 2 to 5 of our reply note. Now, the respondents seek to meet that submission in their written submissions by pointing to Articles 29 and 30 of
Yes.
the Diplomatic Relations Convention. But those provisions don't tell us anything, we say, about the meaning of Article 22. Article 29 is all about the person of a diplomatic agent being inviolable and the need to treat him or her with due respect and so forth.
Yep.
And all Article 30 does is link residence and premises of mission. So they don't in any way alter the ordinary meaning one gets from 22.
Yes.
The second point is that, as the Court of Appeal held at paragraphs 83 and 92 of the judgment, the object and purpose of the Diplomatic Relations Convention would be frustrated if service by post was not permissible, as there would be no means of initiating the proceedings contemplated by Article 31(1)(c) without the consent of the state of the defendant diplomat. And this, perhaps, is another way of putting my Lord Newburger's point that if we're right on Article 31(1)(c), then that really should be an end of the matter, because the parties to the Vienna Convention must be taken to have contemplated that proceedings could be initiated against someone who was not immune from them. Now, it's said in response to that, oh, well, the Court of Appeal's reasoning and Lord Dyson's reasoning was too short to be given any weight. And if we look at paragraph 92,
Yep.
my Lord Wilson has already pointed to the fact that actually Lord Dyson went on to say the receiving state may refuse to effect service by those means. Mr. Daniel was prepared to concede that that subclause amounted to some further reasoning. But the remainder of that paragraph does as well.
I understand.
Lord Dyson is saying that his view about unreliability gains support both from the Travo and from the observations of Chief Judge Bazelon, contemplating that a state might not forward on documents to a defendant diplomat. Now, the references for those,
We looked at Hellenic and Moore.
you did. I don't think you looked.
We didn't look at that
perfectly
passage.
understandable reasons at footnote 3.
We didn't.
And there are a whole series of rather obscure footnote numbering. So I'll just give you the MS reference, if I may. It's A11119, and it's MS 4574.
Thank you. Thank you very much. Yep, I see. Yes, it is.
And the reference to the Travo is MS 1720, AB3, tab 26.
Yes. Thank you.
Now, our submissions in response on this point are also set out at paragraphs 8 and 10 of our response document.
Thank you.
That's our second point. Object and purpose would be frustrated, and there is both recognised in the original Travo and, importantly, the commentary of the ILC and previous case law, a real potential problem in terms of forwarding on from the state. The third point is that the respondents' reliance on the Travo advanced for the first time on this appeal at paragraph 123.4 of their printed case, focusing particularly on one set of observations from one Japanese delegate, don't get the respondents anywhere near far enough for their purposes. The first reason for that is that in their own notice of cross-appeal, the respondents had contended that the Travo were, to quote them, simply not clear enough to be admissible or to give meaningful assistance. That's CV1, MS 45 at 20.
Thank you.
And secondly, if that is wrong, then properly understood, for the reasons given by the Court of Appeal at paragraphs 88 to 90 of its judgment, the Travo strongly favour the approach of Miss Reyes. Now, those submissions are supplemented by us in paragraphs 11 to 15 of these supplementary submissions.
You happy for us to take those as read?
I'm certainly happy to.
On the basis, obviously, we'll look at them.
Certainly, my Lord. One point, if I may,
that I would... particular point you want to emphasise.
I'll do that, if I may. Yes, thank you. So it's 11 to 15 which deal with this. The 2 points I'd particularly like to emphasise, if I may, is that the guidance we get from the Travo is powerfully in our favour for at least 2 reasons. Firstly, the passages cited by the Court of Appeal referring to the views of Sir Gerald Fitzmaurice.
And you've underlined the passages.
We've underlined those.
Passages within the passages.
Yes.
Yes.
And secondly, and this is the point we make at, I think it's paragraph, 12.8.
Yes.
That however gripping the exercise of engagement with the Travo may or may not be, I think it's probably uncontroversial to say that where the comments are reflected in the International Law Commission's commentary, they perhaps deserve greater weight.
I see.
And as we've pointed out at paragraph 12.8 of this note, looking at the ILC report,
You've got the last sentence.
we've got the last sentence.
Understand.
And then the second point is the Court of Appeal's analysis of the Travo, because it's not the case that Lord Dyson overlooked the second Japanese delegate's views. He addressed them specifically at paragraphs 89 to 90. They all arose in the context of an amendment that was being proposed by the second Japanese delegate. And having reviewed the Travo, Lord Dyson concluded many states were opposed to any amendment, and little attention was paid to the Japanese proposal or the basis upon which it was withdrawn. Now, that is, we would respectfully submit, a pretty fatal blow to those singular remarks having the driving force that Sir Daniel seeks to place upon them.
Yes, I see.
That's our third point. The fourth point is that it's said against us that there is a wealth of case law pointing in the opposite direction, paragraph 128 of the respondent's written case. Now, the only case law cited by the respondents is case law concerning personal service, which we're not concerned with here.
Point picked up by Lord Wilson, yeah.
My Lord, yes, and it raises very obvious and different questions, and that applies both to Hellenic Lines and Tachyona.
Yeah. But you have Renchard in
We have Renchard, and Renchard is the only case decided on the question of service by post, unfettered by a domestic statute permitting service by post. And Lord Dyson, we say, rightly found the reasoning in Renchard to be persuasive and essentially to chime with the ordinary meaning one gets from Article 22, that there's nothing remotely undignified about receiving something through the letterbox.
Depends what it is.
The fifth point, my Lord, is that the position taken in the commentaries does not provide the respondents with the strong support they seek either. And the point I wanted particularly to emphasise, given her prominence in this field, is Professor Denzer's observations that we've quoted at paragraph 24(2), where whatever she says about emerging practices or states of confusion and so forth, she says it's unfortunate that the original understanding of the International Law Commission was not reflected in the final text of Article 22. Now, as we've seen, the original understanding of the International Law Commission was that service by post was permissible if the local jurisdiction provided for it. And it would have avoided a lot of uncertainty if that had been reflected in Article 22. And the common sense of this point also goes, we would respectfully submit, to the question that was posed by my Lord Clerk this morning as to how someone is actually to know how to go about service of proceedings in a context such as this. Bearing in mind that it's several years into these proceedings, and only on the Friday before the Monday morning when this case commenced, that we became aware of what the Foreign Office's practice in this regard was.
Yeah.
It's a slight jury point, but I can't just resist making it very briefly in terms of uncertainty. And it's this, that when the matter came before the Employment Tribunal, the respondent's position was that there was no power to allow for service on the respondents, even through the Ministry of Foreign Affairs and the Foreign Office.
Right.
Because there was no analogue to Section 12 of the State Immunity Act. Now, we've done a 180-degree turn from that, and it's said that it's obvious in the light of Section 12 of the State Immunity Act that that's the answer. Now, there's one practical reason, which is the reason Lord Dyson has already given, as to why that doesn't work. Service under Section 12 of the State Immunity Act is by definition service on a state as prospective defendant. And once transmission to that state has occurred, service has been achieved and will be certified by the Foreign Office. There is no analogue here, because all that would happen analytically, once you'd had service on the state and the Ministry of Foreign Affairs, would be that the ball would be in the court of the Ministry of Foreign Affairs to determine when and whether and how it was going to provide that claim form or writ to the relevant defendant diplomat. And for the very practical unreliability problem that Lord Dyson has identified, that's not good enough, particularly when all 193 states have signed up to the idea of exceptions from immunity in the first place. And the sixth point, my Lord, is that the sound reasons of policy, as they characterise them, invoked by the respondents in their printed case at paragraphs 123, 5 and following, are, we say, insubstantial and cannot overcome the meaning of the ordinary words in Article 22. And there are 5 points on that we make, I think, from paragraph 25 onwards in this note. The first is that none of these policy issues were referred to in the Travo.
Right.
None appear also to be supported by the commentaries. Secondly, the facts of this case show that permitting service by post in the manner affected in these proceedings need not give rise to any of the difficulties alleged. Mm-hmm. The respondents were able to make all their points on diplomatic immunity at the earliest possible stage, and the Foreign Office have been able to participate as they would wish.
Yeah.
Thirdly, contrary to the position of the Kingdom of Saudi Arabia, it's clear from the Foreign Office practice, described in their written submissions and their supplemental letter, that service via the embassy is not problematic, and there need not be service in the sending state.
Yeah.
Fourthly, the assertion that service by post could be problematic because of the special duty to protect the dignity of the mission is entirely circular as a point. There's nothing beyond bare assertion to suggest that service by post would conflict with the dignity of the mission.
Yep.
And finally, there's no reason to believe that substantive problems of reciprocity would arise. There is no reason to believe that a United Kingdom diplomat overseas receiving a summons by post would not refer it up the chain. So the only issue relating to reciprocity might relate to some speculative exercise about the reliability of post in different jurisdictions. And that's, we say, a pretty thin reed to seek to displace the
If this
ordinary
cross-appeal succeeds, does that have any knock-on effects on the rest of the case? I mean, does it mean there's never been any service?
It means there's never been any service.
What do we do then? Go back to the beginning and give no judgment on the first point, or what?
I don't think that point hasn't been raised as a...
Hasn't been raised an
jurisdictional-
objection to you deciding the
It's
question,
no.
Well, so maybe we'll forget about it and hope that good sense prevails.
I think one would hope so, my lord, yes.
So far.
I should say, as far as I understand it, in contrast to the position in relation to a High Court claim form, there's no fixed period of validity to the existence, or to an employment.
So you just go around the houses in another direction?
We just go around the house in another direction. We ask for it to be put in the to be collected post box at the Foreign Office. It then goes off to the embassy here. What we don't know at that point is whether it's conceded by Saudi Arabia that that would amount to service at that point, or whether we have to wait for some indeterminate period of time for them to forward it on.
Well,
All of which...
Nobody suggested to us that we can't, or the courts below indeed, that they can't decide what one might call the main point in this appeal.
No.
Without first deciding service has been valid.
Yes, that's right, my lord. All of those points rather drive one, we would respectfully submit, to endorse the ordinary meaning of Article 22 identified by Lord Dyson.
I'm not sure, but anyway, certainly it deals with the point Lord Clark has made, I suspect. But there is, unless it said it goes to jurisdiction. Yep, okay.
So, my lord, those are... I suppose that there would be no difficulty in any event in a case... there are plenty of examples of cases involving contested issues of service, which courts have jurisdiction to resolve, and the fact that they might conclude that service was invalid
By
doesn't mean
definition.
they can't resolve that point.
No, I think the issue is whether we can, if we decide against you
On that point, you leave
can we
everything
then
else
decide
over.
the main issue?
Yes, well, that would be a shame, we'd say.
And as everyone has proceeded on the basis we can, I think we propose to. Yeah.
Yes, well, I hope that's an area where...
You hope it's an academic question anyway, or a hypothetical question.
Yes, my lord. So, my lord...
Well, I wasn't trying to make trouble, I just wondered.
You weren't trying, but maybe succeeding.
So, my lords, my lady, unless there are any further points, that's how we put our position on both appeal and cross-appeal.
Thank you very much. Thank you, Mr. Otti. Sir Daniel.
My lords, my lady, tempting as it may be to use all of the extra 15 minutes in response to Mr. Otti, I don't propose to do so. I think you have our case. There are two very small points which are really just by way of correction, so that you have the point in mind, and I do mean them as by way of correction. I think Mr. Otti referred to Denza and diplomatic law and the original understanding. As I read Denza and the ILC text, the original understanding is the understanding set out by the International Law Commission in its first draft, which is at supplement tab 170, page 23, and the last sentence of the commentary at paragraph 2, which says all judicial notices of this nature must be delivered through the Foreign Ministry of the receiving state. That is what I understand Eileen Denzer to be saying about the original understanding of the ILC.
Can you give me that reference again, please?
Yes, it's the first supplement. It was the supplement to the cross respondents to Ms. Reyes' submissions at page 23. And the second observation is also, I hope, a clarification on the service on the state, and Mr. Otti's suggestion, well, that will just leave the added uncertainty of, well, what happens after it's been served on the state. And it comes back to a point that I was making in my brief submissions just before the adjournment, and that is that it's the state that's the owner of the immunity. Once the document has been served by the Foreign Office on the state, either through the route that we propose or through the route that the Foreign Office proposes, the Foreign Office would certify that service, and the process would have to be a process akin to that under CPR Rule 6.44, subparagraph 5, an official certificate by the Foreign Commonwealth Office stating that a claim form or other document has been duly served on a specified date is evidence of that fact.
But that's service on the state itself.
The
Foreign Office is in a position to certify, but it's not in a position to certify what the state has done to bring it to the attention of the defendant.
I certainly understand that, my lord. But once the document has been served on the state, and the Foreign Office so certifies, it follows from there that the state is on notice about deciding whether or not to waive immunity. And one has to draw a line somewhere, and we are simply saying that that's the place that you draw the line. And my lords, my lady, unless there's anything else that I can assist you with, that's where we will rest.
Thank you very much, Sir Daniel. Well, thanks very much to all the advocates for your oral submissions, which we found helpful. Thank you also to all those involved in preparing the written cases, for which we're grateful. We will consider this matter and let you know our decision in due course. Thank you all very much indeed. Court's now adjourned.